My name is Dusty Brown, and on behalf of the Business Law Society, I'd like to introduce the Financial Disclosures as Regulation panel, and please give a warm welcome to our moderator this morning, Professor Jennifer Taub.
Thank you, Dusty, and thank you to the Vermont Law Review for organizing this amazing symposium. We are just so fortunate to have these experts on this panel, all of whom have taken time away from their busy schedules, and a few of whom traveled from great distances to be here. Because their bios are in the program, I'm just going to briefly introduce them in the order of how they'll speak. First, Professor Joan Heminway from University of Tennessee School of Law. She is an expert on many things, including crowdfunding, which we'll be talking about today. Next to her is attorney Sanford, who is based in Massachusetts but has a national practice related to corporate accountability, which he'll be talking about today. To his left is Professor Ciara Torres-Spelliscy from Stetson University College of Law, who's also a fellow at the Brennan Center and an expert on campaign finance and election law. And our final speaker will be Commissioner Susan Donegan, who is head of the Vermont Department of Financial Regulation. Although I told you I was going to let them speak right away, of course you know that I can't resist saying a couple things first. And that is, there's one person who's not seated at this table, who's not here today, that it would really be, I think, academic malpractice for me not to mention in the context of disclosure. And that is Louis Brandeis. Because he is most well known for something he said 100 years ago. He wrote 100 years ago in a book, first articles and then a book called Other People's Money and How the Bankers Use It. You may have heard this in discussing reform regulation generally. He said that sunlight is said to be the best disinfectant, electric light the most efficient policeman. This catchy expression that's often repeated is more than just either a truism that's true, as Dean Mahoney said, or a truism that's not true. It actually became the backbone for the federal regulation of securities in 1933 and later 1934. And this was a trade-off. Choosing disclosure over product control was a decision to give consumers and investors autonomy and choice, with the expectation that disclosure would breed transparency, and transparency would lead to better informed decisions with regard to the allocation of capital to help businesses and the economy flourish. There are, of course, some exceptions to this, but of course disclosure spread as a technique, not just in securities regulation, but beyond. So our panel is going to talk about this, and I think one of the underlying themes that will come out in this panel and today is how does that work? How is disclosure working to breed transparency and better decision making? And what are the positive consequences in terms of the impact on all kinds of stakeholders? And what are the unintended consequences? So thank you. Welcome, panel.
Thank you, Jennifer, for the great introduction. I think really my talk is going to be a lot more about the limits of disclosure than the positive parts in the end. And I'm not a pessimist, so hopefully I'll make this as upbeat and positive as possible. In my 8 minutes of fame with you for the panel discussion this morning, I really want to raise just 4 points. The first one is I want to focus on securities crowdfunding in particular here, because we have a new law that Congress enacted in 2012 that hopes to bring that about. So I want to talk about what securities crowdfunding is. I also want to answer the question of who the crowd is in crowdfunding and how it relates to that securities crowdfunding definition. I want to talk about how we disclose to the crowd and why we disclose to the crowd. Actually, why first and then the how, and really more normatively the how we should disclose to the crowd. So what is crowdfunding and what is securities crowdfunding? I hazard a guess that a lot of you in the room, unless you've been living in a hole for the last 5 or 6 years, have had some exposure to crowdfunding. But basically what it is it's soliciting and accepting funding. In this case, we're going to talk about businesses today and specifically securities type funding from the crowd. We'll get to that definition in a minute. It's a marriage, really, of social networking and traditional funding techniques. So if you think about seeking donations, or you think about corporate finance, and you marry that with Facebook, that's really what we're talking about when we talk about crowdfunding. Securities crowdfunding, specifically also known as investment crowdfunding, is crowdfunding investment interests that constitute securities under federal or state law, typically, again, using the internet. So that's crowdfunding and securities crowdfunding. What's the crowd? How do we characterize the crowd? Well, there could be lots of different ways of giving the crowd attributes, but for today's purposes, I'm going to be relying on the following. The crowd is heterogeneous, okay? It's heterogeneous economically. It's heterogeneous geographically, socially, politically. Just about every way you can think of, the crowd is not homogeneous, okay? It's disaggregated, spread out, okay? Not just geographically, but in a lot of other ways. So related to the heterogeneity is the fact that people are disaggregated. They're not in groups, okay? It's also internet-based, okay? Technological communicators, these people are in the crowd. They are technologically connected. If they're a member of any group, it's that group that walks around, as my husband likes to say, my laptop is attached to my lap, right? And if it's not in it, then my smartphone, you know, is hoping to make me smart in my pocket and in my hand as I'm walking. I was even here, you know, in Vermont yesterday, out at the Norwich Inn, walking around, and everybody's walking, even on these beautiful streets in this beautiful day, looking down at their handhelds, okay? So that's what we're talking about in terms of the crowd. The crowd can be mad or the crowd can be wise, okay? And there's a large literature out there on that that's based on economics. If we think about the madness of the crowd, the key person we would point to in terms of the literature is Charles Mackay, who back in 1841, so not recently, we're talking Brandeis and Mackay here, right? Has said the following things about the crowd. Men, and we'll have women for these purposes today, that's my edit. Men, it has been well said, think in herds. It will be seen that they go mad in herds, while they only recover their senses slowly and one by one. Mackay also said, we find that the whole communities suddenly fix their minds upon one object and go mad in its pursuit, that millions of people become simultaneously impressed with one delusion and run after it till their attention is caught by some new folly more captivating than the first. Okay? So that's the capacity of the crowd to be mad. The crowd can also, however, be wise, okay? James Surowiecki has written a book that many of you perhaps are more familiar with than Mackay's work, because it's only about 9-10 years old, The Wisdom of the Crowds, Why the Many are Smarter than the Few, and How Collective Wisdom Shapes Business Economies, Societies, and Nations. So that particular crowd, okay, is a collective of intelligence, okay, of wisdom. Crowd-based intelligence, though, depends on certain things, Surowiecki finds. The first one is diversity, specifically diversity of opinion, okay, that opinions in the group differ. The second is independence, that each person is making his or her own individual choice in the decision-making. The third is decentralization, influence, specifically of different bases of knowledge on the decision-making process. And the last is aggregation. Here, again, what we're talking about is aggregating the decisions of individuals into a collective decision. Okay? So that gives you maybe a picture of the crowd. So why would we disclose to this potentially mad, potentially wise group of people? Well, the first answer, I'm a securities lawyer, is mandatory disclosure is a tool of regulation. And if what we're talking about is regulating securities, it's one of the things, along with fraud prevention provisions and substantive regulation, that we look at that are part of the regulatory system for securities. To what end, though? Well, the policy underlying the securities laws is to encourage capital formation, is to encourage business, okay? Specifically by protecting investors and by encouraging fair markets, markets that have integrity. And although it wasn't a basis of regulation in the area, we now know that the efficient capital markets theory, in usually the semi-strong form, so for those of you who are economists out in the crowd, you'll appreciate that reference, explains and predicts to a large extent, but not to a full extent, right, the way our securities markets behave. But information, in fact, does change markets. Information changes pricing in markets, it changes volume in markets, it changes the behavior of people in markets that drive both of those things, okay? But that's not enough, I think, to just say, okay, the regulatory system does that. How does it do that? Okay, what are we protecting investors from? Well, Michael Gutentag at Loyola Los Angeles has written a recent piece that's really fun, that is one of many taxonomies in this area, and he says we need disclosure, mandatory disclosure, to decrease fraud because it encourages accurate and complete statements, and that's independent, by the way, of the fraud prevention provisions in securities regulation. Separately, to correct information asymmetries, standardize information, make sure that there's more transparency, to minimize tunneling or self-interested transactions by insiders, and last but not least, to protect investors from themselves. And that's the part that I have the most trouble with, really, in his taxonomy. Of course, we're not protecting investors from everything about themselves and from all the risks of market participation. But also, increasing market integrity and efficiency is a reason to disclose to the crowd. We can maximize, we hope, the benefits of the market at an acceptable cost to the market participants. So how would we do that? Well, Congress has stepped into the void. The Crowdfund Act, which is Title III of the Jobs Act, crowdfund, that's capital raising online while deterring fraud, and Unethical Non-Disclosure Act. Congress spent more time on the name than the regulations. Okay, and jobs, that's jumpstart our business startups. For those of you who think it means putting jobs in people's hands, I want to disabuse you of that notion, okay? It amends both the 1933 Act that calls for the offer and sale of securities and also the 1934 Act that governs markets. And basically there are mandatory disclosures that are provided for in the Act. So Congress has already told us mandatory disclosure is going to be part of securities crowdfunding. But a huge amount is left to the SEC. They're still regulating in that area, and as with many regulations, including those under Dodd-Frank, as Jennifer knows well, they're late. Okay? So how do we use this to prevent madness? Well, we know very little about the crowdfunding market generally, and we know even less about the market for crowdfunded securities. The securities crowdfunding crowd does have attributes that could make them wise. There seem to be, at least based on what we know now, a diversity of opinion, decentralization of decision-making, and information aggregation. But I worry about whether the judgments are actually independent that the investors are making in this market, or whether, especially with the internet factor, people liking things, okay? Think about it that way in terms of Facebook. People are more prone to engage in hurting behaviors. Just do something, not because it's smart, not because they're weighing costs and benefits adequately, but because it's popular. It's not actually an independent choice, but a choice that's being made not independently. So where does this all take us? Final point. Other than calibrating mandatory disclosures, which is something that we clearly want to do, okay? Several things. The inadequacy of mandatory disclosure, I think, in this environment, because disclosure does not affect things like hurting behaviors, puts pressure on the other regulatory tools that we have, fraud and liability provisions and substantive regulation. And I would assert that the real focus ought to be here on substantive regulation, since fraud prevention relies on the crowd being reasonable investors, which I think we could dispute if hurting behavior really is at issue. The reasonable investor standard could be changed. That would be another way to approach things, but I think the better way is really for us to decrease from what the Crowdfund Act provides the market to a smaller number of people and smaller risk in other ways. Thank you.
Let's see if I can get this. Okay. When I was in law school studying, preparing to be an environmental lawyer, I thought I'd be dealing with the EPA and parts per million and that sort of thing. And instead, by some course of events, I mostly practiced before the Securities and Exchange Commission on environmental law. And my focus is on helping investors examine the management of companies and promote better disclosure on environmental issues in kind of an extra regulatory way. It's beyond things that are actually required by specific regulations. It's based on the idea that if companies are measuring more of environmental and human rights issues, then perhaps they'll manage them better as well. And looking at what's being swept under the rug and trying to encourage companies, my clients who are mostly socially responsible investors or big investors like the New York State Pension Fund, are really trying to get companies often to take the high road. How can they profit without externalizing the costs on society. So what I want to do in this short presentation is give you some concrete examples of how this works and what a couple of the key frameworks are that this happens under. So one of my clients is the Investor Environmental Health Network, which is a coalition of investors who are concerned with toxic chemicals in products and encouraging companies to get those materials out of products. Another example of my client is the New York State Pension Fund and small socially responsible investment funds. A couple of examples of the kind of models that we're talking about. One is where we look at companies' annual reports and we file critiques of what's missing from those reports that investors should have as information. For example, a report that I worked on DuPont. Another example is where we do shareholder proposals at companies. Shareholder proposal at McDonald's resulted in the company through a dialogue process of scrutinizing their potato sources for opportunities to reduce pesticides throughout that system. They're the biggest buyer of potatoes in the U.S. economy, so it was a pretty big breakthrough through a shareholder proposal. Let me give you some examples of some of the key provisions of the law that we use. One is the management discussion and analysis under the corporate annual report, the 10K, which asks for companies to report on trends, demands, commitments, events, or uncertainties known to management and reasonably likely to have material effects on the company. Another is the question about omissions, actually. When you look at the report, what's missing that would be needed to not make this report misleading, whether it's profitability or things they're saying about trends and issues that they're focusing on. A big piece of the puzzle is uncertainty, and I like to focus a lot on the question of scientific trends and whether those trends should be disclosed in companies' annual reports. The interesting piece about uncertainty is that the SEC has been clear that when there's a trend or an uncertainty, basically for the management to not disclose it, they have to say that it's not reasonably likely to occur and not reasonably likely to be material. So the management has to have made those conclusions, and so a lot of my work is building the evidence to show they just can't have that, as that just can't be the case, that they can't say it's not reasonably likely for these things to happen. So an example is where we've critiqued disclosure is in the issue of nanomaterials, various companies that are promoting and using nanomaterials, and where the science began to show that there could be mesothelioma-like effects of certain nano products, and where the disclosure is kind of weak in that area. So we issued a report and we critiqued those disclosures. The other area of my work is in shareholder proposals, and it's sort of, interestingly, seasonal work. It happens before annual meetings. It's like January through March. I'm very busy representing a lot of clients in proposals that will appear on the proxy, provided that the SEC allows them to go through. So companies challenge these proposals, and there are a set of rules, a whole set of different objections that they can make, of which there are two that I want to focus on right now. One is the issue of ordinary business, which is basically an issue of saying that this is the kind of issue that shareholders shouldn't deal with. It's ordinary management of the company, and the second issue is substantially implemented. So as an example, Walmart, we filed a resolution, the Investor Environmental Health Network members filed a resolution at Walmart in 2006 asking the company to report on a chemicals strategy for safer chemicals in products. And the company said, we're the biggest retailer in the economy. We can't, you can't expect shareholders to address this, to even understand the complexities of this issue. For us, we're a big company, it's ordinary business. The SEC agreed, and the proposal never got before the shareholders. But now if you fast forward, and the shareholders didn't stop engaging with the company, they just couldn't get a vote and educate all the shareholders on this issue. Fast forward to September 2013, and the company has now basically adopted a policy that's consistent with what was being asked for back then, and there are many other examples of shareholders engaging with retailers. Hydraulic fracturing is another example where we'll come full circle back to the annual reports. The Investor Environmental Health Network, again, has filed numerous shareholder proposals at hydraulic fracturing natural gas companies, asking them to issue reports that disclose water risks, well integrity, compliance issues, etc. We won the fight over ordinary business. Some of the companies claim that they, so especially one example, Chesapeake Energy put up a big fight saying, oh, we disclose enough on these issues, and we had a big back and forth of 60 pages of documents, technical analysis back and forth. The SEC actually ended up agreeing with us that it was not substantially implemented, but it was really a pretty big evidentiary fight. Fast forward or move forward to the year after that, and the SEC staff now started to, in critiquing companies' 10K reports, the energy companies, they started to ask the same questions that the shareholders were asking. So we really felt like it was actually a process of educating the SEC staff, and now the Investor Environmental Health Network groups are also have developed key performance indicators saying what are the exact kinds of criteria that companies should be reporting, and they're continuing to press on disclosure in this area. So to wrap up, I want to say that this whole area of investors and environment and financial disclosure is certainly another powerful regulating influence for corporate responsibility, and that an interesting aspect of it that I hope you saw from this material is that the SEC plays a varied role. Sometimes they're policing disclosure of companies, but they also are sometimes having discretion and limiting the ability of shareholders to engage on these issues. Thank you.
Good morning. I can't hear you. My name is Ciara Torres-Spelliscy, and I'm going to talk to you about the SEC and dark political money. So this is a picture of my dad. He was an artist, and when I was younger, he would tell me, Ciara, remember to ask the big questions. And the big question that I've been noodling about for a couple of years now is, what is the proper role of corporate money in a democracy? But today's question is, should the SEC be the one that forces disclosure on companies when they spend in politics? So when I started this project, unlike perhaps some of my co-panelists who thrive in looking at SEC regulations, I was really worried that this would be the most boring project I had ever taken on. But once I actually started reading the history and the case law and the things that surround these regulations, I realized that this is just another story about money and power. So the SEC has been regulating money and politics for at least 35 years, and here's how they got into that business. It started in the 1970s, and here's that story. So after a bungled burglary here at the Watergate building, these reporters decided to follow the money. Congress famously held Watergate hearings that interrupted people's soap operas. And what Congress found when they investigated is that money to pay for the burglary at the Watergate building came from the Committee to Re-elect the President, otherwise known as CREEP. And that CREEP got some of its money from these fine organizations, these corporations. And the trouble with CREEP getting money from corporations is it was patently illegal. So as a result of Watergate, famously, Nixon resigns. But what's less known is the SEC's reaction to Watergate. And while housewives all over the United States watched the Watergate hearings, so too did the SEC. And the head of enforcement at the Securities and Exchange Commission, Stanley Sporkin, asked his own big questions, including, how does Gulf Oil account for a $50,000 cash payment to Creep? Do they have an account called bribery? And as it turned out, the SEC looked into the political spending of companies. They started with the companies that had actually been indicted by the special Watergate prosecutor. But then the more that they asked questions about corporate political spending, the bigger the problem looked, the deeper the rabbit hole went. And so eventually the SEC had to declare an amnesty. And they just basically said, bring in your bad news and tell us, and we will make an assessment about what to do. And so 500 companies came forward and said, we too have been spending in politics. And the money wasn't just going to Nixon, it went to the Democrats. And a surprising amount of the money actually went abroad. And the money that went abroad really looked like it was going to bribe foreign officials. So the SEC found a lot of this to be disconcerting. At the time, bribing foreign officials was not clearly illegal under US law. And the other thing that disturbed the SEC was there wasn't a proper reporting of this money, and it was at a material level to the extent where publicly traded companies were putting out financials which were not accurate. So the SEC, after they discover this rat's nest, they take on an almost lobbyist role, and they urge Congress to pass a new law, which then becomes the Foreign Corrupt Practices Act, or the FCPA. And the FCPA does a lot of things, but for our purposes today, it makes it illegal for businesses to bribe foreign officials in order to maintain or get business. And that includes political contributions abroad. So ever since the 1970s, the SEC has had jurisdiction over campaign contributions abroad if they are given to bribe a foreign official to get business. And they do enforce this part of the law. Titan was hit with a hefty fine for violating this part of the FCPA. So moving from the international to the local, the SEC also has jurisdiction over money in politics in the municipal bond market. So the municipal bond market, one of the ways to think about it is when a city or a town has a project that they want to build, but they don't have the money to do it, they just put it on credit. And they borrow the money on the bond market. And there are about 1 million different, like literally 1 million different municipal bonds out there. And the nomenclature is a bit of a misnomer. It covers not just city and town bonds, but also state bonds. And one of the things you could think about is what could possibly go wrong if you gave 50,000 different political entities in the United States a credit card. One of the risks is if they don't have fiscal responsibility, then they can literally, just like an individual, they can borrow more than they can pay off. And so you can have municipal bankruptcies. And this is not theoretical, see Detroit. There's also a risk of political corruption because the entities that bring the bonds to market are your friendly neighborhood investment banks. And the investment banks compete for that business. And one of the ways that they compete for that business is by giving campaign contributions to, for example, mayoral candidates who eventually will have control over whether that city issues bonds and which investment bank they choose to do business with. And I love this quote from David Clapp. He's a partner at Goldman Sachs, and he describes what pay-to-play looks like when it's in your face. And so he's at this dinner, someone comes up to him and says, I need a $50,000 contribution for a political candidate. And David Clapp sort of laughs at this person and says, I don't have $50,000 to give to your candidate. And the response back is, well, then you're not going to be doing business with that person. So if you don't pay, you don't get to play. Enter Arthur Levitt, the chair of the SEC under Clinton. He came to the job with a passion to get rid of pay-to-play. And under his leadership, the SEC gets behind Rule G37. And this rule basically makes it illegal for those who do business in municipal bonds to give more than a de minimis amount to one of the candidates that has control over the municipal bond business for that entity. And this rule gets challenged by William Blount, pictured here. Mr. Blount is now a guest of the state, but that's another story for another day. His pay-to-play sort of caught up with him eventually. But back in the 1990s, he challenged this on constitutional grounds, but his challenge was rebuffed. The DC Circuit said there's actually a really good reason to have this anti-pay-to-play rule, and that there's a conflict of interest that is self-evident. So ever since the 1990s, the SEC has had jurisdiction over pay-to-play in the municipal bond market. And because I know our time is short, I'm going to skip over the public pension fund pay-to-play law. It is very similar. So, and of course, we also have public officials who go to jail over pay-to-play in the public pension fund market, including the comptroller of the state of New York, which leads the SEC to promulgate the new rule. And so that was a mouthful. What else is new? I think what's new is Citizens United, which is the 2010 case where the Supreme Court says that corporations have a constitutional right to make independent expenditures in electioneering communications, what normal people would call political ads. And corporations are using their new Citizens United rights. You may know Gulf Oil from my Watergate example earlier by its successor name, Chevron. Chevron was the biggest on-the-books publicly traded company to spend in the 2012 election. But I'm less worried about this type of spending, which is actually transparent. What I'm much more worried about is the dark money that's coming into our political system. So basically, if a corporation wants plausible deniability when they spend in politics, you just route it through a nonprofit. And the nonprofits of choice tend to be 501c4s and 501c6s. And once it goes through that nonprofit, the public simply can't tell which corporation is behind which political ad. And according to my friends over at Demos, $300 million of political spending in the 2012 election came in dark. And by dark, I mean you can't tell what its original source. So in response to Citizens United, 10 law professors petitioned the SEC asking for a new rule that would require corporations that are publicly traded to tell their investors where they're spending this money in politics. And a record-breaking over 600,000 individuals have commented on this petition urging the SEC to act. And I would argue that the investing public needs to know where this money is coming from before it goes dark. Thank you.
morning, everyone. I'm from the government. You know how that ends. I'd like to do a sort of a Donegan disclaimer. It's my own kind of disclaimer. Not everything I say will necessarily be the official position of the Department of Financial Regulation, but you may not know what it is I'm saying that's mine and the department's. That's my disclosure. You know, it's kind of a fun moment to be here at VLS, and it's an amazing topic right this moment, because there isn't an issue that's more on fire in financial services right now than the issue of who should know what, when, and how, and including in our local way here in Vermont, that the issue of disclosure, public records exemptions, what do people have the right to know, what do they need to know, is something that we deal with at the legislature, within state government, and obviously in the private sector every day. This is a conversation that my staff and I had even yesterday with members of Ledge Counsel's office. So very timely and well done, everyone, for picking a topic that's alive. So it's also interesting how many people stayed for financial services regulation. You know, there's nothing faster to clear a cocktail party than to tell folks, I'm a regulator, particularly when you say insurance regulator. So let me just give you a little bit of a basis for the point of view as a regulator in all of this, and that is that we have confidentiality and exemptions from public records, and that is a framework that's a time-honored framework. It may give some people some heartburn, but there's a real reason for why we designate certain information to be confidential and exempt from public disclosure. And that has to do with the fact that we understand that when we ask basically private companies to, as a condition of their license, to disclose highly sensitive information and allow us to get into every nook and cranny of their lives, what you have to give in return is an assurance that that information is going to be used in a regulatory fashion, not placing a company in a competitive disadvantage if that information got out. So that vital level of cooperation between regulator and regulatee is really the basis for what we see as you know, vast exemptions from public records information, and as well as individual confidentiality. It's also a tool, a regulatory tool for us to be able to know enough about a company and also share that kind of information among regulators, both federally and state. And at the department, we regulate insurance companies, captive insurance companies, banks, non-depository institutions, the list goes on, broker-dealers, investment advisors, and all of the sales folks that are out there licensed to sell products connected with that sector. So you can see on the banking and security side, as you know, that's a dually regulated, those are dually regulated sectors. So there's a great deal of back and forth between state regulators and their various federal counterparts. Not so much on the insurance side, and I'm going to drill down in a very locavore way right this minute and focus on insurance regulation, because that is a state-based framework. The insurance back, McCarran-Ferguson, 1945, you know, see, I do know the law, basically gave insurance regulation the province of the states, except for a few notable exceptions. You know, we know ERISA, crop insurance, flood insurance, those types of things have been carved out. And what we have is we have the 50 states, DC, and the territories all doing a similar approach to insurance regulation. So, as Vermonters, as a Vermont regulator of insurance companies, let's even take a step deeper. Let's say Vermont regulators of health insurance companies, and you can imagine there probably isn't a topic that is more incendiary right now than health insurance regulation and those evil, evil companies and health reform that we're going through, all for good reasons. So let me tell you about what we do as regulators in terms of disclosure and confidentiality. And when I say disclosure right now, I'm talking about the relationship between the regulator and those that are regulated. There's also disclosure between what a public should know, right to know, or need to know. And that's a little bit different take on the disclosure aspects. It's more closer to the securities part of what should an investor know in a material way in order to make a good decision. So for health insurance, a couple of years ago, by the way, insurers file so many reports and so much data that it is mind-boggling. But every year, insurance companies must file an annual report, a regulatory report, that gives us a great deal of insight into not only the financial picture of the company, but what the practices are that they're following, so that when we wind up doing a full audit every 3 to 5 years, we've been tracking the regulatory and practices that are in place to make sure that they've been in compliance. And, it's a report that, we as regulators, we know what it says, we can see it, we can put our fingers on the information, but consumers, they may have a more difficult time seeing some of what they think might be important information for them to see how their insurance company is functioning in the marketplace, and perhaps they might want to know that. So our legislature a few years ago decided that it would be good to gather what they thought was information that consumers had a right to know and put it into one document, so that people could just go to that document and see this great information that would inform them as consumers about not only what's going on at their local health insurance company, but they may have a national company. They might want to know some more information. So you'll see up here on the board that this document, very official looking here, it's called the Addendum to Health Insurer Annual Statement. That's the thing they file with us every year about the financial status of the company. But what they've done is the legislature said for those insurance companies that have at least 2,000 lives that they write health insurance policies for, we want to know some information in this special form so that consumers can take a look at it. And what I've done is that this is all public information. This is not confidential. This is right on our website. Go take a look sometime. By the way, you should read our website. It's really just incredibly exciting. Oh yeah, I read it all the time. So let's just drill down here a little bit and see what I'm going to show you. Now I'm picking on Blue Cross Blue Shield, okay? Only because that was the first one in line, and it's also the health insurance company that we are the primary regulator for. So we are their solvency regulators. And that word needs to stay in your mind for the rest of my comments, solvency. That is what our job one is at the Department of Financial Regulation, and that is that we are to maintain the solvency of financial institutions and insurance companies in this state. And think about it. Can you think of a better consumer protection than solvency? If you don't have solvency, the rest of it is meaningless. So let me just get down here, because we're into corporate officers and board compensation. Oh my gosh, the chief executive officer of Blue Cross Blue Shield makes $574,913, and he gets about $12,000 in other compensation. You see up at that top line. Holy cow, that's amazing. That's an amazing salary for Vermont. Do you need to know that before you buy health insurance? Do you want to know that before you buy health insurance? Does that influence your decision about where you're going to buy health insurance? I don't know. But maybe it's a good piece of information for us to have, because Blue Cross Blue Shield is a nonprofit company. So does that influence this number? Drop down, we're paying board members, about $30,000 to sit through, anywhere from 16 to 30, sit through board meetings. I don't know. I don't know if that's good or bad or a lot for this particular company or for the kind of effort they put into being board members. But now let's go down and see that marketing and advertising expenses by Blue Cross Blue Shield is about over $700,000. They are only a Vermont company, and that's their total marketing and advertising. But here we've got lobbying expenses. Federally, obviously, they don't need to lobby federally. They are a state entity. But they lobby to the tune of $258,000 here in Vermont. They're at the State House. There's an incredible amount of legislation that has to be monitored right now, particularly with health care reform. So perhaps in the last couple of years, this number has gone up dramatically. I don't know. I haven't seen 10 years ago what the lobbying expenditures were. But here, political contributions. We are requiring disclosure of political contributions by this regulated entity. They disclose they have none. But they also show us that they have about $55,000 in a payment to their trade association, and that's what we call the Blue Cross Blue Shield mothership. It's the Blue Cross Association that's of a national association. And some other types of payments. One is about legal expenses involving claims and other types of service denials. And then ultimately, we want to know if they contributed to our charitable environment here in Vermont. And in fact, they've given Vermont charities about $46,000. So, and we can do this for all of the health insurance carriers that are selling here in Vermont with more than 2,000 lives. Another one is MVP. Now, their numbers will be all over the map very differently. I'll just tell you, their CEO gets over $1 million. Their political contributions are zero. Their lobbying efforts are not as much. Their boards get no money for serving. But would it change your opinion of $1.2 million for the CEO also to tell you that that's a company that is a New York company that has, it's a holding company type group that's got about 12 companies underneath it in New York, Vermont, and New Hampshire. And so that it is a much larger company. Some of those subsidiaries are for-profit, some are not. There are other types of allied health companies within that umbrella. Does that change your opinion as to whether or not that CEO deserves $1 million? I don't know. But here's the question about the right to know, which we believe there should be a right to know, and here's the right to know, versus human nature. And that is, do you need to know? Do you want to know? Do you actually use this information? I will tell you that when we post this annually, because it's an annual filing, and I checked some stats yesterday, that we've had 14 hits for this information. And we culled out how many times we actually give it to you. I will tell you, I know who the 14 are. You know, Vermont's a small state. It's the media. It's the media. And you can see the spike right after it's published. There's a quick rush. Let's get it. You see the corresponding, stories in the news. And so the information somehow gets out there, and it's usually very spectacular. Oh, big salary. Ooh, whether there's political contribution or whatever. And that's really the main group who look at this information. The other group that looks at this information are the carriers, the insurance companies. So Blue Cross is going to quickly go see what MVP gets. MVP is going to look at Blue Cross because this is a way for them to calibrate where they sit within the marketplace itself. So my question is, and again, we follow the law. We believe in the types of disclosure that consumers really need, and I think a previous speaker talked about authentic disclosure versus just to make it look good. What do consumers really, really want in order to make an informed decision about how to buy health insurance in Vermont? I make a suggestion that it's not whether Don George is making $500,000. I make a suggestion that it's called a price point, that they are going to look at the website for the health exchange and they're going to see that a particular plan for Blue Cross versus a particular plan for MVP has a $75 differential for the same benefit package. Where do you think they're going to go? I guess in that situation, the Blues wins. So I raise this as just, this is the way we work at the department. It's always a balancing act for us on an everyday basis on what information is exempt, what should be exempt, how do we as regulators balance the differences between what should be known, what should not be known, and what people want to know. There's a lot that should not be known. I will tell you, you should not know the risk-based capital number for Blue Cross Blue Shield. It is a tool for regulators, subject to misinterpretation by consumers that could do something like similar to like a run on the bank if it wasn't truly understood. So that we have made some decisions about what should not be within the public domain. And that's a heavy burden as regulators, and we carry that every day. And I would like to take my last 30 seconds and Commissioner's prerogative and go off script for a minute. I'm noted for this. And I want to make a pitch to the students in the room. Raise your hand. Wow, wow, great. And I think there are probably among you some terribly misguided environmental law folks. Terribly terrible. Look, the message here, financial services regulation is an incredible career path, and I think it's one worth considering. It's a statutorily driven sector. If you didn't figure this out, lawyers are the bedrock of interpretation, good or bad, in this sector. And so whether a lawyer, you become an analyst, you become an investigator, examiner, I think it's really worthwhile within somebody's career to take a stint in government, wear the hat, understand what the issues are and the burdens and the trust of holding the public in your work every single day. There are 8 of us at the Vermont Department of Financial Regulation that are VLS grads. And in addition to myself, I graduated in 1986. I made them all come here. So they're here in the audience, and I'm going to make them wave their hand because I would urge you at the breaks, lunch, cocktail parties, to go talk to them and say, what the heck do you do? Now, if you ask them that and you find out, would you let me know? So from the class of 1978, David Martini. Fast forward to 2009, Brenda Luciano. Brian Martin and Noel Hudson, both from class of 2010. Shannon Salambier and Carla Nusso, 2011. 1986 grad Tom Van Cooper with me in class wasn't able to be here today, but I have 3 more folks to identify. One is a recently graduated law clerk who also did his semester in practice with us last year, as what we give people really good titles when we abuse them. So he was the special assistant to the commissioner, Jared Bianchi, 2013. And now we have our current law clerk that we're putting through paces. You know him as Mr. President, Christopher Smith, and he will also be joining us for a future SIP in spring. Last but not least, Dale Shaft is our information management officer, and Dale deals with the public records requests that come in. Timely, turn them around, get these lawyers to get the information out to the public, because in fact, we do understand disclosure, and we do understand the importance that public records and information plays in getting to the hands of folks. So that's my pitch to all of you. It's been great, and now we're going to get some questions.
So thank you all. That was amazing. I'm going to ask a quick question of each panelist, and I want to have a lot of time for you all in the audience to ask questions. I'll give the commissioner a break and won't ask her the first one. But I want to pose the first one to Professor Torres-Spelliscy, because like so many others in this panel, her work is cross-disciplinary, where she found herself doing securities and corporate law when she really was interested in election law and campaign spending law. And so the other day, she wrote something I'd like her to explain. I thought she had, crossed boundaries enough, but can you explain the relationship between cheeseburgers and campaign finance for us?
I would love to. Okay. So I have spent a lot of time on Watergate, and part of it is it's one of the most complete records of corruption you will ever get in American history. And one of the things that kept on bubbling up, and I thought it was an urban legend, but it is not, was the story of Ray Kroc. So Ray Kroc was the head of McDonald's, and he had two things that I think that he wanted. One, he wanted to lower the minimum wage for his teenage workforce. And two, he wanted to raise the price of his cheeseburgers when Nixon had put in price controls. And so with the minimum wage, he almost gets it. Congress has a law, they're about to gut the minimum wage for teenagers, but at the last minute, they don't do it. And that bill was known as the McDonald's bill. When Congress guts what was known as the sub-minimum wage, Nixon actually vetoes it, and that veto becomes known as the McDonald's veto. And then in terms of the price of the hamburger, at the time, Nixon had price controls. He was trying to stave inflation, which meant that there was this price control entity that you had to go to as a business and ask for permission to raise your prices. And McDonald's raised the price on their quarter pounder without going to the price control police. And so the price control police dinged them on it initially and say, you've got to drop the price of the cheeseburger back down. And then mysteriously, after Ray Kroc gives $250,000 to CREEP, which is the equivalent of $1.3 million today, the price control police reversed their decision on the price of a quarter pounder. So that's the link between money that goes to a politician and results of how much it costs a consumer to eat a cheeseburger in the 70s.
Thanks. And now I have a question for Professor Heminway. So what you all may know or may not know is that she was one of the first people to study crowdfunding. But what very few people know is that even though she's very pro-business, she actually killed some early crowdfunders. But what's fascinating to me is she did it through a law school exam. Can you explain yourself?
Yeah, so it may sound like a tangential sort of connection like cheeseburgers and political spending, but yeah, what happened is I started investigating crowdfunding well before there was really sort of almost a name to it because I was concerned about securities regulation in that area. So I started testing my students on it, first with a final and then with midterm examinations, and this is when there were very few websites out there that were trying to use the internet to help fund businesses in a way that I would consider crowdfunding. A natural outgrowth of that business was that the early crowdfunding business was that people started asking people for investments that were going to have a little profit with them, and that made it into securities crowdfunding before securities crowdfunding was legal. So these businesses were all operating illegally. This is why it was a great exam question, right? Because I could give it to the students and let them find out that there were these businesses out on the web that were operating illegally. And this is while I'm in the background writing about it, but before articles have come out. Someone who wanted to form a crowdfunding business actually went out there and found my exam and realized I understood what was happening legally. So this is an entrepreneur, a social entrepreneur actually, for those of you in the room who are interested in social enterprise, and contacted me and told me about his business model, and I said, it's patently illegal. What you're doing is patently illegal. Hire a lawyer. So he did, and I told him that was not legal advice, but he should hire a lawyer, right? Which we all have to do when people call us about these things. And we had a long conversation over it. He went out and he kept on finding these businesses like I was finding that were violating the laws, and he started doing their Q&As in the background while he's developing his business. He develops and launches that business. And others were out there like ProFounder, for those of you who followed the crowdfunding industry. And then we started writing about it. People were not just finding my exam, but they were finding other things. And those businesses, ProFounder had to shut down. Its business model was illegal. 33 Needs, which was founded by the gentleman who called me, was in operation for about a year before. It also had to go out of business. And I can assure you there still are businesses out there, we do not have crowdfunding regulations yet, that are operating illegally that are still great fodder for my exams. So I haven't taken everybody down yet, Jennifer, but that's the connection between my exams and...
But one little follow-up. In fairness, you actually think that these would be good models and that where we've ended up with the legislation is not necessarily the place we should be, right?
Yeah, exactly. So there's a cost to disclosure. You've heard almost all of us, I think, either say that or at least allude to that, right? I think if we can calibrate, and it's a cost of regulation really generally, if we can calibrate disclosure and if we can understand a little bit more about the crowd, and as I said at the end of my presentation, sort of tune things down so that we have, so that social entrepreneurs can use this, for example, so that people who are funding films, people who are funding indie bands can use this and still give a little scintilla of a profit to somebody. If we can do that either by exempting them from the registration requirements of the securities laws or by at least saying that those are not securities, if it's just a scintilla of a profit, I think that we can get a business model that works and that encourages business in the appropriate way that the securities laws should.
Right. And now a question for Attorney Lewis. You gave us some examples of where your clients weren't able to get before the shareholders at the meeting a vote on some issues, but nevertheless, behind the scenes, companies sort of voluntarily got the message and complied. But can you talk about maybe some victories or how the voting has gone? Because you've talked about the proxy statement, which is, you know, the invitation to the annual meeting, and there's a ballot, and if you're successful, your client's proposal will be on the ballot. Have your clients ever won a vote? And what has been the outcome when they win? Because these are merely advisory; they're not binding usually.
Right. Actually, some of my clients are actually doing binding proposals by asking for bylaw amendments and having votes on this. But right, most of them are voluntary. And you know, the funny thing is when you see reports of shareholder proposals in the media, the reports always say the proposal lost. And from the perspective of my clients, if we get 10% of shareholders of a company to say that the company needs to pay attention to an issue, that's already a message to the company and changes the discourse in and with the company. We've been having, on some of the hydraulic fracturing proposals, for example, there have been votes in the 40% range, and there have been some that I think have been over 50%. So,
sorry,
on these
to interrupt
issues,
on that. Sorry, just on
yeah.
So what would a fracking proposal look like? Students may think, you know, it doesn't say stop fracking. What would a proposal say?
It would. There's several different ones. One of them asks the company to talk about what they're doing about community impacts. Another one asks them to issue a report that quantify. Right now, there's a big emphasis in these proposals on getting the company to quantify metrics about hydraulic fracturing. You know, how many green completions, how many of this and that. You know, sort of technical. You know, fairly technical things. Reporting on compliance trends, so you know, penalty numbers over the course of years, so investors can look at trends. So a lot of these issues. So it's mostly they're asking for a report in the instance of the hydraulic fracturing ones, and I would say 50% of sort of social and environmental proposals ask for some kind of a report.
Right, thanks. And one last question for me, for Commissioner Donegan. This is your second tour of duty at the department. Do you have any war stories you might want to share with us about maybe how the kinds of work the Commission has done, and I guess in particular, the department has done, in particular, I'm thinking about the ways in which state security, you talked about this dual regulation. With insurance, there's not dual, but with securities, we know we keep talking about the SEC, which is the federal level in Washington, and then there are the state commissions and departments that have a role in securities offerings. Over the years, that role has been tapered and changed. Do you have a view on your experience when you had more of a role in the offering process, and whether that was good or bad, or any other type of thing?
Yeah, it is my second tour of duty. I started out as a very young lawyer in 1985 to 90 at the department, and wound up being the first securities director. Back then, we had the 1929 Securities Act, the original Blue Sky Act, as our tool. In fact, we didn't change that until into the 2000s. And one of the things that happened with that law is obviously didn't keep up with the markets. I mean, we were doing things like having to individually approve employee stock option plans because the ESOP concept was not something that was even around in 1929. So there was a lot more interaction at the market level. And in terms of offerings themselves, it was also an environment where going to market, going in an IPO or those types of even intra or interstate offerings was much more possible. I mean, think about Ben & Jerry's. You know, that's always my favorite war story. You know, I can tell you that on the eve of December 1987, in a blizzard, they were truly driving like crazy people up from Boston to get the filing to me as I sat there waiting to stamp it in so that it would be on our record and they could get to market by Monday. The courier almost, you know, drove off the road 4 times. And we sat there till midnight to make sure that, you know, subordinated debenture through Tucker Anthony got to market. So, you know, obviously times have truly changed. But what's also changed is that it's tougher to go to market now. It's really hard to go the regular way. It's expensive. There's high risks in that. And I have seen coming back now, 3 years ago and now as commissioner, that with the SEC having over the years say, no, we're going to do merit review. The states really don't need to do that. We rely on the states. That has now taken a back seat to us in some ways. And I think that that's not always good. We are the local folks, particularly for local investments, for alternative energy companies here in Vermont, for solar companies that are looking for ways to find alternative investment. They can't go to a bank. They're not going to get you know, a loan. They've tapped into their credit cards. Their mom says no. You know, but they need to be able to do something that puts them into the market. So I think crowdfunding, alternative investments, I mean, I think we're seeing a renaissance or a revitalization with that a little bit.
Great, thank you. So questions from the crowd?
Don't ask for funding.
Please state your name and your affiliation.
I'm Zachary Chen. I'm a 3rd year here at the law school. This question is for anyone, but it might be of most interest to Professor Torres-Spelliscy. I was interested to hear about the proposed rule that would require companies to disclose to shareholders where political contributions are going. And I was wondering, sort of in keeping with the theme of authentic disclosure, if you could discuss how to bridge the gap between a company disclosing to shareholders where money is going to disclosing to voters where their ad is coming from.
So I guess a few responses. One, right now it's only at a petition stage. So we have the original petition from the 10 professors. We have the 600,000 public comments saying, please, 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 please act. What we don't have is a rulemaking from the SEC. And it, I think, will be up to the new chair, Mary Jo White, whether she chooses to engage with this rulemaking. So that's one. Another response I would give you is our friends in the UK are much better at regulating corporate money in politics, I think. Number one, they require shareholder approval before corporate money is spent in politics. And in addition, they require yearly disclosure directly to shareholders in the annual report, accounting for where they spent it in the first place. And so my ideal, what I think we need post-Citizens United, is something very akin to what the UK has and has had for the past 10 years.
Other questions?
I'm Brad Smith. I'm with West Virginia University School of Law and also the Center for Competitive Politics. This question is for Professor Torres-Spelliscy and also for Professor Heminway. You've mentioned now a couple of times over 600,000 comments to the SEC. I was just looking at their website. 639,000 of the comments they've received are form letters. Over 40% of those are a single form letter that was drafted by Common Cause and the American Federation of State, County, and Municipal Employees. That is a large union. That form letter begins, "I'm deeply concerned about the influence of corporate money on our electoral process. In particular, I'm appalled by the Supreme Court's ruling in Citizens United versus Federal Election Commission." The second letter, or a second letter, comes from Bill de Blasio, current New York City mayoral candidate. He sent out when he was public advocate, and it begins, "In January 2010, the Supreme Court issued a ruling that opened the floodgates for increased corporate influence in our election. The decision, Citizens United versus FEC, rolled back the long-standing restrictions on corporate spending in elections." And these other letters are the same. I wonder if it is really fair to suggest that these letters represent concerns of the investment community, which is what you've suggested it is. And my kind of follow-on for Professor Heminway would be just to ask, from your point of view in looking at herding and so on, and the ability to just click the like button, do you have any thoughts about whether this is the kind of thing that the SEC should rely upon? And for both, whether this is not an example of how the SEC getting involved in non-material spending by corporations, specifically for political reasons, might in fact embroil the SEC in political controversy that will harm its mission as being a disclosure agency for securities and capital markets.
Okay. I will agree. A lot of the letters to the SEC have come in the form of form letters, but there are also very substantive letters put in by various investment groups, including a lot of state treasurers. And one of the things that I skipped over in my presentation is, if you think of something like the New York State Retirement Fund or the California Retirement Funds, they have billions of dollars invested on behalf of public retirees. And they have weighed in on the side of wanting more transparency for corporate political spending. So, number one, there are the public entities like Bill de Blasio, and I think he was writing in his capacity as the public advocate. And as the public advocate, he is one of the trustees for investing New York City's massive pension fund. So he is writing in his capacity as an investor. And I think it's totally appropriate for investors to question whether corporate funds, which are other people's money, as Justice Brandeis would put it, whether that money is being spent in ways that they would find either personally objectionable or just an utter waste of corporate resources.
So your question for me is really longer than we have time to answer, and I'm assuming we might want to get one more question in before lunch. But it's a great question, and let me say, and Sanford may smack me for this, shareholders are not always the right people to make these decisions, I'll be honest. And he and I can have a much longer conversation about that. That would be a whole disclosure debate all afternoon. But I do think they are often good to engage in the process. And obviously they can be co-opted and grouped, and the kind of herding behavior I'm worried about is what you're observing. I would submit to you that the SEC over time, under most of its chairs and with most of its commissions, has been relatively wise in how it pursues regulation when it's enabled to pursue it on its own. I'm actually a fan of the Securities and Exchange Commission, okay? I think in the crowdfunding area and in other areas, including Dodd-Frank that we've seen recently, Sarbanes-Oxley, Congress has dictated things. It's Congress that's killing crowdfunding, folks. It's Congress that has placed undue regulation burdens on the SEC and put them in the position that they're in right now. It's an unexpertized, but yes, we elected them, group of folks who are driving that process. And sometimes I think they do good work, and sometimes they don't. And I think the same is true for the SEC, but I have a lot more confidence in their expertise and their ability, again, under most administrations, as a party of five that must be bifurcated between Republicans and Democrats to do more effective and efficient work in the area of securities regulation.
Great, so time for one last question. I'm looking around.
There's someone behind you.
Oh.
I'm Christopher Smith. I'm a third-year student. I'm curious if there is, there's a lot of disclosure, there's different forms of disclosure, and, in capital markets specifically to the SEC, and it seems like a lot of information, is seen as a good thing, but is there a point of critical mass where, investors, and I'm thinking more the unsophisticated investor, is inundated with information and therefore the disclosure becomes counterproductive?
Yes. I wrote an article on this that talked about whether disclosure in the Dodd-Frank context is just more of the same, the SEC just instituting more disclosure regulation, or whether it's TMI, too much information, right? There is a point at which people don't read, they don't absorb, even if they have the capacity to do that information when there's too much out there. The concept of materiality in securities law is intended to get at that. It's not always perfectly effectuated through judicial opinions and regulation, but that's the intent, is to make it sort of clear for the reasonable investor that they have what they need. Mandatory disclosure can be both under-inclusive and over-inclusive, okay? And so sometimes we push, I think this was suggested by our commissioner, too much information out to people, and other times it's calibrated much more wisely to the people that need it. I think Sanford has something to say too.
Yeah, I certainly agree that there can be too much information, and in the sustainability arena, there's a whole organization that's trying to define what are material pieces of information for different sectors. This sustainability, SASB, whatever that stands for. The other piece of this that I think we also need to focus on is the fact that we live in an age of computers and the ability to drill down in information. And so I think the whole system hasn't caught up with the fact that it's possible now to have layers of information and to drill down locally on issues and so forth. And so I think the system is evolving to catch up with that fact.
One more comment?
Let me put on my election law hat for just a second here. I think that voters need heuristics, otherwise known as mental shortcuts. And I think one of the mental shortcuts that they are missing is who is behind the crazy negative ads I'm seeing. And so part of why I'm pushing for the SEC to have this disclosure is so that those voters will have that mental cue.
Great, well, thank you. Enjoy your lunch, and thanks to the panel.